and as it is now apparent, the facts in this suit are not in dispute, and the substance of this petition is primarily the interpretation of Article 261 of the Constitution, and in particular, whether in his advice to the President to dissolve Parliament, the Chief Justice acted intra vires this particular provision of the Constitution. Owing to the character of the petition of being more legal oriented rather than fact-based, there has been very little or no distinction between what parties have pleaded and submitted. In other words, their respective submissions mirror what has been not only pleaded, but what has purportedly been represented in the affidavits as evidence on oath. We say purportedly because most of what has been sworn in the affidavits in support of and in opposition to the consolidated petition are either legal arguments or a reproduction of various provisions of the Constitution. With this background in mind, it would be repetitive to reproduce each of the parties' respective submissions at this stage of the judgment. But we will refer to those submissions as much as it is necessary to resolve what we have identified as the issue or issues for determination of this petition. Speaking of issues, the National Assembly and the Senate to which the advisory was targeted identified the following issues for determination. A, whether the constitutional principles under Articles 27(8), 81B, and 100 of the Constitution can be achieved without affecting the basic structure of the Constitution protected under Article 255(1)(c) on the sovereignty of the people. B, whether Parliament can legislate under Articles 27(8), 81B, and 100 to alter the composition of Parliament without offending the ceilings of representation set out in Article 97 and Article 98 of the Constitution. C, whether the Chief Justice, in his advice to the President, misconstrued his role in transmittal of the advisory letter and therefore ignored his dual functions in his capacity and or exercising 1, a judicial function, 2, an administrative function, 3, if so, whether the advisory is justiciable and reviewable by the High Court under Article 165(3) of the Constitution. D, whether the Chief Justice misapprehended his constitutional mandate and obligation under Article 261(7). E, whether, having been advised as such by the Chief Justice, the President has any residual discretion under Article 261(7) regarding the dissolution of Parliament when read together with Article 131(2)(a), B, C, D, and E of the Constitution. F, whether the advisory letter offends against the principle of parliamentary privileges, immunity, and debate under Article 117 of the Constitution. G, whether Parliament has envisaged under the Constitution acts in succession or not. If the answer is in the affirmative, 1, was the order targeted towards the 11th Parliament? 2, would the order affect the 12th Parliament? 3, should the order be read in terms of Article 261(8), which talks about separate and distinct Parliament? H, whether the Chief Justice can interfere with the ongoing legislative process when the debate on the representation of the special interest groups, Amendment B 2019, is ongoing. I, whether the Chief Justice has powers to interfere with the legislative mandate of the 12th Parliament despite the 12th Parliament having 2 more years to conclude its terms that runs from August 2017 to August 2022. These issues raised are to a greater degree more representative of the issues raised by the rest of the petitioners and respondents together with the interested parties, in the sense that they are largely common issues except that they have been differently framed. Our reading of the Supreme Court advisory in advisory number 2 of 2012 and the several court decisions arising out of cases that have been filed over the years in the quest for the enactment of the relevant legislation for the implementation of the 2/3 gender rule reveals that most of these issues have been litigated upon. In the Supreme Court advisory opinion in the matter of the principle of gender representation in the National Assembly and the Senate 2012, for instance, the Attorney General sought the advisory opinion of the Supreme Court on 2 issues, one of which was whether Article 81B, as read with Article 27(4), 6, and 8, Articles 96, 97, 98, and Article 177, 1B, 116, and 125 of the Constitution required progressive realization of the enforcement of the 1/3 gender rule, or whether the same was to be implemented during the general elections scheduled for 4th March 2013. The second issue was whether for Articles 97 and 98 to support the transformation of Article 81B from the principle to right, the two would have to be amended to incorporate the element which the Learned Counsel, Mr. Kanjama, referred to as a hard gender quota. In the alternative, a legislative measure as contemplated in Article 27(8) would have to be introduced to ensure compliance with the gender equity rule, always taking into account the terms of the Article 97 and 98 regarding numbers in the membership of the National Assembly and the Senate. End of quote. To emphasize this point, the court opined, I quote, as Article 81B of the Constitution, standing as a general principle, cannot replace the specific provisions of Articles 97 and 98, not having ripened into a specific enforceable right as far as the composition of the National Assembly and the Senate are concerned. It follows, and this is the burden of opinion on this matter, that it cannot be enforced immediately if the measures contemplated to ensure its crystallization into an enforceable right are not taken before the elections of 4th March 2013, then it is our opinion Article 81B will not be applicable to the said elections. The effect is that Article 81B of the Constitution is amenable not only to progressive realization, even though it is immediately applicable in the case of county assemblies under Article 177. End of quote. The Supreme Court then asked itself a question that is not only pertinent to the issues raised by the parties in this petition, but also answers questions many of those issues have raised. To quote the learned judges of the Supreme Court, they asked this, I quote, "That leaves open the question, if Article 81B is not applicable to the March 2013 general elections in relation to the national legislative organs, then at what stage in the succeeding period should it apply?" This, we believe, answers the compelling question raised in the contest to the case of progressivity. When will the future be as a baseline for implementation of the gender equity rule? And in answer to this fundamental question, the court opined as follows, I quote, "Bearing in mind the terms of Article 100 on promotion of representation of marginalized groups and of the 5th schedule prescribing time frames for the enactment of the required legislation, we are of the majority opinion that legislative measures for giving effect to 1/3, 2/3 gender principle under Article 81B of the Constitution and in relation to the National Assembly and the Senate should be taken by 27th August 2015. End of quote. The court did not leave it at that. It spelled out what we would regard as a default clause in the event legislation was not enacted in the following terms. I quote, "The foregoing opinion is a basis for action in accordance with the terms of Article 261(6), 7, 8, and 9, under the transitional and consequential provisions of the Constitution, by way of the High Court being duly moved to issue appropriate orders and directions." End of quote. So the Supreme Court effectively sanctioned the action of setting in motion the process that would ultimately culminate in the Chief Justice advice to the President to dissolve Parliament in accordance with Articles 261, 6, 7, and 9 of the Constitution, if the relevant legislation would not have been enacted by 27 August 2015. Suits which were filed subsequent to the advisory, and in particular after 27 August 2015, must have taken cue from this default clause. As a matter of fact, according to the judgment rendered in the Center for Rights Education and Awareness versus the Attorney General and another, on 26 June 2015, the petition is said to have been filed, quote, to give effect to the Supreme Court advisory opinion, as well as the respective constitutional and legal provisions, certain legislative actions, possibly with a bearing on the constitutional amendments, which were required to be taken by 27 August 2015, end of quote. In that suit, the petitioner sought for, inter alia, a declaration that to the extent that the first and the second respondent have this far failed, refused, and or neglected to prepare the relevant bills for tabling before Parliament for purposes of implementation of Articles 27(8) and 81(b) of the Constitution, as read with Article 100 and the Supreme Court advisory opinion dated 11th December 2012, in reference number 2 of 2012, they have violated the obligation under Article 261(4) of the Constitution to prepare the relevant bills for tabling before Parliament as soon as reasonably practicable, to enable Parliament to enact legislation within the period specified. In allowing the petition, the court, Mumbi J, as she then was, held that there had been failure on the part of the Attorney General and the Commission on the implementation of the Constitution to exercise their respective mandates to enact the requisite legislation. Since the deadline set by the Supreme Court was not yet due at the time the judgment was rendered, the court held that there was a threatened violation of the Constitution by the two respondents in the suit with respect to the exercise of their mandate under Articles 261(4) and Section 5(6) of the 6th Schedule to the Constitution. The court further granted an order of mandamus compelling the respondents to prepare relevant bills for tabling before Parliament for purposes of implementation of Articles 27(8) and 81(b) of the Constitution, as read with Article 100 and the Supreme Court advisory opinion. Another case in which the question of gender representation prominently featured post the Supreme Court advisory opinion was the Center for Rights, Education and Awareness, and two others, versus the Speaker of the National Assembly, and two others, which, as noted earlier in this judgment, is the case that birthed the order on which the Chief Justice acted. The court captured the core issue in the petition as whether Parliament had failed to fulfill the constitutional obligation to pass legislation that gives effect to the 2/3 gender rule, and if so, whether the petitioners could invoke the mechanism provided in Article 261 of the Constitution. Following the Supreme Court's advisory opinion, the court held that Parliament had failed, refused, and or neglected to implement the measures contemplated under Article 27 and 100, and made a declaration to that effect. The court, as noted, directed the National Assembly and the Attorney General to take the necessary steps to ensure that the required legislation was in place within 60 days from the date of the order. The Court of Appeal upheld this decision in the Speaker of National Assembly versus Center for Rights and Education and Awareness, where the court held as follows. It captured the crux of the appeal as follows. I quote, "At the heart of this appeal is the question whether Parliament has failed to enact within the stipulated period legislation that is required to fully implement the Constitution of Kenya 2010, and whether, as a consequence, the default mechanism provided by Article 261 of the Constitution, leading ultimately to dissolution of Parliament, should now be invoked. End of quote. Among us, the issues the Court of Appeal grappled with were whether the Parliament's failure to enact legislation to implement the two-thirds gender principle violated the right to equality and freedom from discrimination and breached the constitutional timelines on the enactment of legislation and whether Parliament should be dissolved. Whether Parliament had taken the requisite legislative measures for the realization of the two-thirds gender principle, and whether the petition ought to have been instituted against all individual members of the National Assembly and of the Senate rather than the speakers. The Court of Appeal cited the Supreme Court's advisory opinion and several provisions of the Constitution with respect to gender representation and held inter alia that Articles 27 and 81 of the Constitution left no doubt in the Court's mind that the Constitution contemplates that elective public bodies, including the National Assembly and the Senate, would in their composition comply with the gender principle. As to how this could be achieved, the Court was of the opinion that there was three possible ways, the first of which was through elections. Under this method, voters would, in exercise of their democratic right, elect representatives of mixed gender into elective positions. The Court acknowledged that this particular method had proved futile, hence the need to include the two-thirds or the one-third gender principle in the Constitution. The second method is what the Court affirmed as having been set by the Constitution itself. However, the Court regretted that this method was restricted to the county assemblies only, leaving out the National Assembly and the Senate. The Court noted that the Constitution contemplates that in democratic elections, it is possible that the required minimum numbers based on gender will not be achieved. Hence, for the county assemblies, Article 177(1)b provides a formula for achieving or satisfying the gender principle. It is for this reason that the Constitution provides that a county assembly is made up of, firstly, of members elected by the registered voters of the wards. Secondly, the number of members of marginalized groups, including persons with disabilities and the youth, as prescribed by an Act of Parliament. Thirdly, the Speaker, who is an ex officio member. And lastly, the number of special seat members necessary to ensure that no more than two-thirds of the membership of the Assembly are of the same gender. We have also been asked to determine the question whether the order that was to be transmitted was restricted to the 11th Parliament to the exclusion of any subsequent Parliament, including the 12th Parliament or the current Parliament. It has been urged on behalf of the speakers of both houses that the life of Parliament is tied to its term, and therefore the order in issue was exclusively directed at the 11th Parliament. According to this argument, the 12th Parliament would not have been affected by any court order issued during the life of the 11th Parliament, since each Parliament has a separate and distinct lifetime linked to an election cycle. The two speakers raised this question with the Chief Justice before he rendered his advisory. However, the Chief Justice discounted the notion that the order was restricted to the 11th Parliament and held as follows. I quote, "The argument that the order in Constitutional Petition number 371 of 2016 was directed to the 11th Parliament has no basis. The obligation under Article 261(5) to enact legislation and order in that petition was directed to Parliament as an institution and not the 11th Parliament." End of quote. Two provisions in the Constitution provide some guide on whether a court order directed to Parliament is restricted to and only enforceable during a particular term of Parliament or binds Parliament as an institution. Article 93(1) of the Constitution provides for the establishment of Parliament as an institution. It reads as follows: Establishment of Parliament. There is established a Parliament of Kenya which shall consist of the National Assembly and the Senate. On the other hand, Article 102, Clause 1 of the Constitution defines term of parliament. It reads as follows. Term of parliament. The term of each house of parliament expires on the date of the next general election. What is clear from these provisions is that parliament is not defined on the basis of any particular term to which members of parliament have been elected. As an institution, parliament exists in perpetuity, independent of terms or any one of them, during which members elected in a general election sit. The two provisions provide a clear distinction between parliament, the institution, and the term of parliament, which, as noted, is tied to an election cycle. The nature and the character of the institution of parliament under Article 93 of the Constitution is that it is transcendental. It is beyond the sum of its individual representatives. It is some kind of a permanent constitutional corporation with autonomous legal personhood and not a fluctuating or shifting political assembly. It is a structured, symbolic, and constitutional institution, and to some degree, a culture or doctrine, rather than a mere sum of representatives. Its rules, roles, administrative apparatus, cultural practices, and constitutional position give it a continuity and identity beyond the changing membership. This stems from the principle that individual members of parliament are temporary occupants of a continuous, immutable constitutional office. Based on the theory of corporate personality and institutional continuity, parliament operates as a corporation aggregate or an abstract legal person. It has rights, privileges, immunities, and legal powers that do not dissolve when individual members are, for instance, ousted by loss of an election, retire, or pass away, or where there is a fresh election cycle. While individual politicians come into office through a democratic elections, and their term limits are determined by constitutional cycles, the structural entity of parliament never dies. Its legal rights, obligations, responsibilities, and constitutional position remain completely intact. Parliament, like a corporate entity as a legal personality, are completely distinct from its members. In the context of public law, this principle ensures that the actions, liabilities, and statutory articles of a previous parliament strictly bind the state, even where there is a completely new membership. Further, following the concept of procedural and constitutional continuity, it can be argued that if parliament were merely the sum of its members, as the petitioners have suggested in their case, the death or resignation of a majority of members would legally and automatically extinguish the legislature. However, the existing constitutional framework is such that there is a preservation of the legislature as an arm of governance, allowing it to function continuously through established quorums and procedural rules. We need not belabor the point that Article 94 of the Constitution explicitly vests legislative authority in Parliament as an institution, not as individuals. It declares Parliament represents the will of the people and exercises their sovereignty as an organ not cascaded into individual fragments owned by individual elected politicians. Article 94, in a way, embodies John Locke's and Jean-Jacques Rousseau's social contract theory, as discussed by Eulabel B. in his article, Locke and Rousseau, From Natural Freedom to the Social Contract, found in the Journal of Philosophy, where it is posited that political power is artificial and its legitimacy is drawn from individual consent. According to this theory, the agreement concluded by all its participants, that's the electorate, is considered the basis of a true political body that a form of government that binds naturally free people is created through a political association based on the concept of a contract. In other words, that a sovereign power that originally belongs to the people is donated to members of parliament by virtue of the offices they hold which connotes a permanent institutional vessel, not individual members of parliament themselves. Thus, the vessel ought not to be confused with the souls on board. This point was captured by Edmund Burke in his speech to the electors of Bristol 1774, referenced in P.B. Calland and A. Lanner on the Founders of the Constitution, Volume 1, Chapter 13, where he stated as follows, I quote, "Parliament is not a congress of ambassadors from different and hostile interests, which interests each must maintain as an agent and advocate against other agents and advocates. But Parliament is a deliberative assembly of one nation with one interest, that of the whole," end of quote. In the South African case of economic freedom fighters and another versus the Speaker of National Assembly and others, that was recently decided this year, the Constitutional Court of South Africa cited its earlier decision in Women Legal Center Trust versus the President of the Republic of South Africa and spoke of this issue as follows. Quote, the court orders issued in respect of the National Assembly continue to apply to its successors, even after a particular National Assembly is dissolved. An election is conducted and the composition of the National Assembly is changed. In that matter, notwithstanding the relevant lapse and change in composition after election, the order of this court remained extant, unaffected by the elections, and Parliament was obliged to pass the contemplated legislation by the deadline or seek an extension. Incidentally, it was an issue to do with enactment of legislation by Parliament. Thus, when the courts issue remedies for legislative failures, the orders issued or declarations made are directed at Parliament as a constitutional organ, not individual members of Parliament. This further entrenches the postulation that Parliament is a permanent institution accountable for its systematic constitutional obligations and not a fleeting body of its individual membership. Without belaboring the point, the institution of Parliament established under Article 93(1) transcends its membership, such that where Parliament is tasked with a legal obligation, the obligation outlives the term of Parliament. Parliament cannot be said to be discharged from its constitutional responsibilities merely because the term of Parliament, when they arose, has expired. Parliament's constitutional responsibilities are not personal to individual members. They are institutional responsibilities that transcend the term of Parliament when they accrue. Upon election to either houses of Parliament, the members' role is to ensure that Parliament delivers on its obligations, irrespective of when they arose. The speakers of the two houses belabored under the rather mistaken notion that, like bills of Parliament, the court order in petition number 316 of 2017 was restricted to a specific Parliament, such that when the term of that Parliament expired, the order lapsed. It is true that Standing Order number 141 of the National Assembly Standing Orders and Standing Order number 163 of the Senate provides that a bill, the consideration of which has not been concluded at the end of the term of Parliament, shall lapse. We are of the firm position that a declaratory order under Article 261(6)(a) is not equivalent to a parliamentary bill. Unlike bills of Parliament which lapse with the expiry of the term of Parliament, a court order under Article 261(a) does not die with the fluxion of time. A similar argument was dismissed by the Constitutional Court of South Africa in Economic Freedom Fighters and another was the Speaker of National Assembly, where the court emphasized that the National Assembly rules, equivalent to our standing orders in the case of our Parliament, cannot override constitutional provisions. The court held, I quote, secondly, it might be argued that the National Assembly rules do not apply to executive functionaries in the same way they apply to the National Assembly, and that given the stipulations of Rule 351, the decision has lapsed and is now moot. That is, the court cannot revive a motion that has been extinguished by the National Assembly rules. But such a view is untenable, as it would elevate the national rules above the Constitution's provisions, which require consistency with its injunctions and render orders of the court orders binding. In the Speaker of the National Assembly versus the Center for Rights, Education and Awareness, the Court of Appeal gave a bit of the history of Article 261(7), which affirmed the position that an order under Article 261(6)(a) is intended for the institution of Parliament and survives the parliamentary term. Citing the final report of the Committee of Experts on the Constitutional Review, dated 11th October 2010, the court held as follows, I quote, "We ask ourselves, why did the Constitution deem it necessary to provide the default mechanism in Article 261? In our view, it was simply to guard against the legislative inertia or inaction, which would thwart or frustrate the fully implementation of the Constitution. This is borne out by the first report of the Committee of Experts, which drafted the Constitution, where it was stated thus: the new Constitution also set out a procedure to be followed if a law was not enacted within the scheduled time. The challenge was to ensure that the new laws envisaged by the new Constitution are promptly enacted. Under Article 308 of the Bomas draft, if Parliament failed to adopt a particular law within the time stipulated in the table, anyone could petition the High Court for a declaratory order instructing Parliament to enact the law within a specified period. If this was not done, Parliament would be dissolved. The new Constitution follows the Bomas draft, the Bomas approach, in allowing the National Assembly to extend the time within which a bill is to be passed, provided that the extension is justified by exceptional circumstances and has the support of at least 2/3 of its members. It also permits any person to petition the High Court to deal with failure by the National Assembly to pass a law in time. If the National Assembly fails to abide by the court order, it will be dissolved and a new election held." End of quote. Our conclusion on this subject is that the order made in High Court Petition number 371 of 2016 transcended the 11th Parliament and remains a valid order capable of enforcement. Until it is complied with, the order bound the 12th Parliament that was then in session when the order was issued, and it still binds any subsequent Parliament, including the current Parliament. For this reason, it may still be transmitted to the Attorney General and the Parliament by the Registrar of this Honourable Court in accordance with Article 261(6)(b) of the Constitution, as read with Section 20H of the High Court Organization and Administration Act, in which event the timeline prescribed by the Court for Parliament and the Attorney General to take the necessary steps towards enactment of the relevant legislation will start running from the date of transmission. For these reasons, and the reasons that we have given, we allow the consultative petition against the advisory opinion in the following terms. The Chief Justice advisory dated 21st September 2020 is hereby declared unconstitutional, null and void. The Chief Justice advisory dated 21st September 2020 is hereby removed into this Honourable Court for purposes of quashing and is hereby quashed. An order of prohibition is hereby issued prohibiting the President of the Republic of Kenya from enforcing the advisory by the Chief Justice advisory dated 21st September 2020. Now, this being a public interest litigation, would make no orders as to costs. That's our order.
Thank you so much, my lords and ladies. We appreciate that very, very detailed judgment that has been delivered in time, schedule. We wish to just make a request that we may supply with the copies of judgment I believe it will also be accorded. We also that we can advise our clients. My lords and my ladies, on that last link where the registrar is being advised to transmit the order by Justice Matibu to the Attorney General, you're wondering whether that order can be made a bit express clearly to the Register of the High Court to make that transmission.
Yes, we are sure that the Registrar of the High Court will be able to read our judgment and act accordingly.
Unfortunately, they didn't read it when the people delivered, so we are just trying to be cautious.
Yes.
On behalf of the speakers of Senate and Parliament, on the last thing of what my learned friend Mr. Wambola has requested, I think for neatness it would be appropriate for those orders to be sought in that specific file rather than this one, so that we can contain the proceedings within that file and not this one. These petitions were specifically to challenge the advisory